Whakataka te hau ki te uru. Whakataka te hau ki te tonga. Kia mā kinakina ki uta. Kia mā tarata ki tae. Kia hi aki ana te atakura. He tio, he huka, he ho-ho. Ti hei mauri ora.
Good morning, everybody. Welcome to day 4, the last day of hearing private settings. We have before us Submitted Audrey Campbell Fraser. Freya, sorry, mistake. And Sarah Shaw, you're the barrister at the new case.
Yes, that's right. Kia ora panel. Good morning. I'm Sarah Shaw. I'm counsel for Audrey Campbell Freya. Online, we have Ian Hanmore, who is the soils expert, and Derek Foy, who's done the economics expert evidence. Sitting with me, Melissa McGrath to my left, your right, who's our planning evidence. And with the panel's indulgence to my right, I have Te Karira Ruakira Norris, who is a planning student who is interning with Melissa's firm this summer. And I thought I'd invite him to sit in the big seat rather than hiding in the back corner.
You're more than welcome. You present previously.
Yes, I was present with David.
Okay. Welcome back. I hope enjoy the proceedings and it doesn't put you off attention too much.
So TK won't be giving evidence. He's here for learning. Thank you. Now, I did provide some paper copies of 2 things. So you would have had pre-circulated in the evidence round. We had the soils evidence, the economics evidence, and the planning evidence. Subsequently, then had the council's economic evidence come in. And so Mr. Foy has prepared a response to that. So that was circulated online, and you should have a paper copy of that as well this morning. I also pre-filed legal submissions. And this morning I've handed up what's now colloquially become known as counsel's notes, which is really just rather than relying on you taking notes of coming at the end of the hearing. As you say, we've had the advantage of hearing some of the panel's questions. We did listen to the reporting officer's opening. So the council's notes here are really just some structured introduction to today. Has the panel had an opportunity to read the pre-circulated evidence and the pre-circulated legal submissions? Or?
We read the pre-circulated evidence.
Yep.
So the legal submissions were brief, so
yes,
it's quite handy to read those.
Okay.
And I think you provide something.
So I provided a copy of recommended changes from the rural production zone.
Sorry, yes, that's right. Yes, with the legal submissions was a marked up set of provisions for how could the ARPROS accommodate the issues. So yes, we have those as well.
So I think we've got in between you. Understand?
Okay, great. And then, so what I'll do is I'll start with the submissions. Just trying to find which are on. Go. Make them bigger so I can see them. So I'll just take you through the pre-circulated legal submissions first, and then I'll just come to the council's notes, which is more of a response to the hearing as it's unfolded so far. So at paragraph 1.1, the introduction, Audrey Campbell Freya is primary submitter and further submitter, and there's 4 themes of her submission. It is the first of the themes, which is to delete the horticulture zone that's relevant to this rural hearing, and really just flagging at the outset that by delete the horticulture zone, that the submission is to just apply the rural production zone in its stead, to not have a horticulture zone, to just have the rural production. So at paragraph 1.4, as I've indicated this morning, we've got Ian Hanmore has provided soils evidence and is online. Derek Foy has provided economics evidence and is online. And Melissa McGrath has provided the planning evidence and is in person. So in terms of what is sought and what is not, The evidence is that highly productive land must and should be protected. That's the starting position that's, I think, common amongst a number of parties. The submission and the evidence is that the creation of a proposed horticulture zone as a special purpose zone is not an appropriate planning mechanism to protect that highly productive land, and simply that the rural production zone is the right mechanism. The national planning framework, and I wanted to really just sort of take us back to what is the statutory and national direction about what we're doing here. So the council must prepare the proposed district plan in accordance with the NPSHPL planning standards and section 32, and the proposed district plan must give effect to the NPSHPL, the standards and the RPS. To give effect to means to implement and is a strong directive creating a firm obligation, so King Salmon, and must is a highly directive word, it's mandatory language. The purpose of the NPSHPL is stated in its single objective, which is highly productive land is protected for use in land-based primary production. The planning standards, the purpose of those is to improve the efficiency and effectiveness of the system by providing nationally consistent structure, format and definitions. And in terms of definitions, as we know, the NPSHPL defines highly productive land prior to regional mapping, so in the interim, as LUC 1, 2 and 3. And the standards define primary production, and the NPSHPL definition of land-based primary production both include horticulture. So that's our starting position. For zoning and horticulture, a district plan must only contain the zones that are listed in the standards or a special purpose zone. And the standards direct the use of the rural production zone for areas that are used predominantly for primary production activities, including horticulture, that rely on the productive nature of the land. The standards direct that a special purpose zone must only be created when the activities or outcomes meet all of the 3 listed criteria, which is they have to be significant, which is why the economics evidence has looked at whether the area of land within the proposed horticulture zone is significant, not because of trying to denigrate the horticulture industry, but because this is the mandatory statutory test. It has to be significant to the district, region or country in order to have a special purpose zone allocated to it. It has to be impractical for those activities or outcomes to be managed through another zone, and impractical to be managed through a combination of layers. And all criteria have to be met. So the evidence of Mr. Foy from an economics perspective and Ms. McGrath from planning perspective is that none of those 3 mandatory criteria are met. And even if we were wrong about that, you have to meet all 3. And I have in my council's notes I've handed up this morning, I've leaned into some of the questions you've asked about what do some of these words mean, how directive is it, so I'll come to that. So for zoning and highly productive land, the NPSHPL interim definition is that highly productive land as a starting point has to be zoned general rural or rural production and LUC 1, 2 or 3. For practical purposes, we always lean into the LUC 1, 2 or 3 end of that sentence. But the start is really important. It's not highly productive land unless it's zoned general rural or rural production. And Far North District Council is proposing to zone this land something that is neither of those. The Regional Council's obligation under the NPSHPL to map highly productive land applies to land that is general rural or rural production zone and predominantly LUC 1, 2 or 3, large geographically cohesive. So the starting position for protection of highly productive land is that it is to be in one of those 2 zones in the standards. And the NPSHPL defines zone as the zones in the standards. So there appears to be a potential problem in the future through applying the horticulture zone. So what does this mean The government has, through the NPS-HPL and the standards, which is national direction, top of the tier, established an efficient and effective management regime for highly productive land and for horticulture. And it's assigned that job to the rural production zone. The NPS-HPL and the standards are both highly directive about the methods that the council must use in its proposed district plan to zone land for primary productive activities, including horticulture. It must use the rural production zone. The standards are highly directive about the mandatory criteria that must all be met before a special purpose zone can be used as an exception. And the onus is on the council to demonstrate that this exception can be met. And we say that none of those criteria are met for the proposed horticulture zone. And as I said earlier, even if we're wrong about that, all of them have to be met. So it's not a case of any one of them triggers it. At paragraph 1.23, the NPS anticipates that highly productive land will be zoned rural production zone. Now, arguably, if you have land LUC 1, 2, or 3 land that is not rural production zone, it will be ineligible to be treated as highly productive land under the interim definition and ineligible to be mapped by NRC as highly productive land in its regional mapping. That can't be the outcome that the highest direction at national level was looking for. The NPS-HPL is the highly directive national instrument specifically cast to protect highly productive land for land-based primary production, horticulture, and it does not anticipate a special purpose zone for horticulture. For all of these reasons, I submit the proposed horticulture zone does not give effect to the national policy statement and the standards, and therefore it's not compliant with where we started, which is I took you to sections 74 and 75, the council's obligations. So the evidence of Mr. Hanmore, Mr. Foy and Ms. McGrath, and I'm not going to summarise all that for you, you've read it, is that the proposed horticulture zone fails section 32. The objectives do not achieve part 2 of the Act. The proposed zone provisions are not appropriate, and other practicable options, the rural production provisions, are the most appropriate to achieve strategic direction and the RPOS objectives. The proposed horticulture zone provisions are inefficient and ineffective because they duplicate the RPOS provisions. They restrict the zone to Kirikiri Waipapa area by a policy which does not implement its own objective, even for this proposed zone. They apply a horticulture zone to a spatial area where 90% of the uses are not horticulture. And the provisions apply a zone purporting to manage land fragmentation to an area that's already fragmented. The proposed horticulture zone fails to meet any of the 3 mandatory standards criteria for a special purpose zone because horticulture in Kirikiri Waipapa is not significant at a district scale. The irrigation scheme is not significant to the district or region. It's not unique and it's got unacknowledged constraints. And highly productive land, horticultural activities and reverse sensitivity can and must be practically managed by the rural production zone, or a spatial layer could achieve it. Ms. McGrath says we don't need one. LUC 4 land is not defined by the NPS-HPL as highly productive land. It is not defined by the RPS as versatile soils. By its own definition, as Mr. Hanwell has drawn out, it has severe physical limitations to arable use. And within the proposed horticulture zone, contrary to the section 32 assertions, Mr. Hanwell's evidence is that it could not sustainably lift production through irrigation due to the risk of erosion and slope steepness. That's why it's LUC 4 in the first place. The council has not recognised the costs of restrictively zoning land subject to these avoid policies as a holding pattern. This is the LUC 4 land, when NRC is not currently progressing its mapping for good reason. And FNDC has no plan to review this restrictive zoning when highly productive land is later mapped. The evidence of Mr. Foy on economics and Mr. Hanmore on soils is uncontested at the time I wrote these submissions, as neither the council nor NRC have called economics or soils expert evidence to support the creation of special purpose zone. Now, subsequently, of course, the council has called economics evidence. I know I don't need to caution the panel about NRC having filed a planning statement that includes a paragraph from an economist. It's not evidence, it's a paragraph. So from the written submissions perspective, and then I will then take you to this morning's notes. In conclusion, the proposed horticulture zone does not give effect to the mandatory and directive NPSHPL and the standards, and it does not pass section 32. The rural production zone is mandated by national direction as the appropriate zone for the protection of highly productive horticulture. Ms. McGrath has prepared a markup of the ARPOS provisions to demonstrate to you that it is practical for the rural production zone to manage horticulture. In fact, if it doesn't, we've got a big problem because the NPSHPL says that it has to. The proposed horticulture zone should be deleted and the rural production zone applied in its place. And of course, we have future zoning hearings about what that looks like. And then my final note that given the government's commitment to amending the NPSHPL, I have an obligation to inform a panel who have not yet made a decision or a court who have not yet released a decision if there are any law changes or case law that comes through. That's not an opportunity for me to provide you with any restatement of case or submissions. It is simply that I have an obligation to inform you of any changes in the legal platform. And so I need to do that. So I did have the council's notes that have been handed up, and it's just a couple of pages, but I think it might be useful to take you through because it then takes us from where I started in written submissions to now that I've heard the council's opening and some of the panel's questions on the first morning to just try and tie these things together. So at paragraph 1.1 there, just indicating that Audrey was is a Kiri orchardist. So if there was any doubt as to, not that someone needs a motivation or a role to involve themselves in a proposed district plan, but this is an orchardist who is bringing a soils expert to tell you that a proposed horticulture zone hasn't hit the mark. Many of the submissions are pulling in the same direction. Protection of highly productive land for land-based primary production activities, such as horticulture, including from fragmentation and reverse sensitivity. So we're actually, I think a lot of us telling you the same thing. It's just that we're saying that the most appropriate planning tool is not yet settled. And the team have listened to the reporting officer's opening comments and the panel's questions. And Audrey has also attended some of these hearing days in person. So from the reporting officer's opening comments, as the reporting officer's statements, I could hear very clearly on the recording. When Ms. Worcester was speaking, it was much harder to hear her. I'm not sure that the microphone wasn't picking her up as well. And the chair's questions were very clear. Some of the panel's questions were less clear on that first morning, but we have listened. So the first theme I took from the reporting officer's opening comments is that there's an issue as to whether the horticulture zone is the most efficient and effective tool to protect the horticulture industry in Kirikiri and Waipapa. So Ms. McGrath's evidence addresses why this policy directing a zone to Kirikiri and Waipapa of the proposed horticulture zone. So it's not an objective of the zone. The objective's much higher. This is only a policy that directs it spatially to Kirikiri and Waipapa. That policy does not actually implement the proposed district plan's objectives or give effect to the NPSHPL, and that the council's proposed horticulture zone does not protect the horticulture industry or the irrigation infrastructure in Kirikiri Waipapa more efficiently or effectively than the ARPOS would, or in other areas of the Far North district at all. So the proposed district plan has made a decision to leave all other horticulture areas and all other horticulture irrigation to be protected by the rural production zone. So Kirikiri Waipapa has been singled out, and Ms. McGrath says that the zone actually doesn't protect it in the way that it aims to do. So at 1.6, using ARPOS would protect them all. And the next theme that I picked up was that spatial extent of the horticulture zone or LUC soils is evidence for a later topic, and that perhaps the submitter's evidence is off topic. My response to that is that zoning is and always will be a spatial planning tool. The council's proposed horticulture zone is justified in the 32 and the 42A as addressing specific spatial issues. So the whole reason for creating this zone is the protection of a particular industry and particular infrastructure in a particular place and not elsewhere in the district. That's a spatial reason. And also as applying to LUC 1 to 4, not the HPL definition of LUC 1 to 3. And so that is also a spatial justification for a zone. And the evidence for Ms. Campbell-Freer has expressly not engaged with the most appropriate zoning site by site within the proposed zone, very carefully indicated that those zoning hearings are for next year. What we've focused on is that the rural production zone is more appropriate than having a proposed special purpose zone for horticulture. And that's the issue that was evaluated in the 42A report. So if our evidence has gone off topic into spatial areas, the 42A report, we've responded to the 42A report, which addressed all of these spatial issues of LUC4 and the irrigation infrastructure. So I think we're all on the same topic. And the next theme that I picked up was that the horticulture zone needed to give a strong policy direction backed up by restrictive rules for decision makers to fall back on to reject applications in Kirikiri and Waipapa. And Ms. McGrath's evidence is that the proposed horticulture zone does not actually do that, but the RPROS can. And the MPS HPL requires that the RPROS does do that. So all of these issues of reverse sensitivity, fragmentation, highly productive land, the MPS HPL says that the rural production zone has to manage all of that. That's its job. Panel's questions that I picked up on from that first morning: how directive are the national planning standards? So the directive language I've already addressed in the legal submissions, all the must and the mandatories, but I have actually then taken a step back because I thought a very interesting question about what is the purpose of national planning standards. So I went back into the sections of the Act that govern national planning standards. So 58 capital B, the purposes of the standards are to set out requirements for plans. 58 capital C, standards may direct councils on structure, form and content. And 58I, councils must take the action directed by the standards. And the zoning standard is a mandatory one. So it doesn't get much more directive than mandatory. The next question I picked up is, what is the meaning of impractical in the special purpose zone criteria? So I did look at the dictionary definitions of not effective, cannot be done effectively, but I've also looked at the case law for you. So Court of Appeal level, they were discussing practicable in that case, but they said that dictionary definitions do not give much assistance because interpretation of that language must take into account the particular context and the statutory framework. So the word takes on the meaning of the specific usage. And the High Court, when it was looking at, this is the Tauranga case about the pylons, looked at practicable, practical and possible in a series of policies. And again, similar to the Court of Appeal, had said that the meaning requires interpretation and analysis in the context of the specific wording. So I footnoted those cases forward. And at paragraph 115, both of those align with section 10 of the Legislation Act 2019, which is the replacement for the old Interpretation Act, that the meaning of legislation must be ascertained from its text and in light of its purpose and its context. My legal submissions address the directive nature of the standards generally, which was to achieve national consistency, and of the zone framework standards specifically. As I said, it is expressed as mandatory direction. I do note that submitters, I think it might have been the Vision Kirikiri grouping, have referenced in a footnote of theirs that MFE guidance on RPROS indicates that councils use alternative zones to manage productive capability of land. I would note that that is guidance. It's not the text of the standards itself, and the Environment Court's been quite clear that guidance has a limited role in interpretation. But equally, my reading is that that guidance explains the background to why the standards included both a general rural zone and the rural production zone in the zone framework standard, because RPROZ was selected as the zone to manage productive land. So my reading of those guidelines that you were pointed to is that they explain why the standards include 2 rural zones, so that one of those is targeted to the management of productive land. In terms of next steps, I noted that, if I heard correctly, I think that the reporting planner indicated that when the NPSHPL is amended, an addendum 42A report may be produced. And it was a little hard to hear this next part, but I think I heard that the soils expert for the council wasn't available this week to answer any questions, but might provide some comment in the reply. I may have misheard that. And I've noted there that the council did have the opportunity to, it wasn't a timetabled step, but they did have the opportunity to provide rebuttal soils evidence, as the council did with economics. For both of those, I would say that fairness, as the panel will be well aware, is likely to require the opportunity for submitters to have a response if new evidence is produced in reply, or if an addendum 42A report is produced. If the submitters have not had an opportunity to comment on that material, it may require another round. So those were the legal submissions and the sort of notes to update us to the end of the hearing and what we've heard and what our responses are. So I'm happy to take any questions about the legal submissions if you have them, or move into the evidence.
Yes, thank you.
Thank you, Sure. I have a couple of questions. Your submissions are very clear, and I understand the points you're making. I just wanted to explore the spatial extent side of things, because I did pick up on Mr. Floyd's evidence that he's saying it's not as simple as just going rural production. You do have to kind of figure out where that rural production zone might start and finish. And what you're saying is it's something for later on.
So at the separate round of hearing, there will be the hearing of submissions about, on a site-by-site basis, what is the boundary of any given zone for those spatial areas people have indicated in their submissions. So the purpose of this hearing and this aspect of the submission is only to challenge the introduction of a horticulture zone as a concept. The reason it gets really muddied really fast was also flagged in the 42A report. It is a spatially justified zone for 2 reasons: to specifically protect a local industry and its local infrastructure in the Kirikiri Waipapa area, which is by definition spatial, and also to include LUC4 land as a buffer, which is spatial because it's mapped. So we are not here to try and unpick at this stage of the hearings whether rural production across the board over what is currently mapped as proposed horticulture zone would be the right site-by-site solution. But as a planning technique, what we're saying is you do not need a proposed horticulture zone, because the rural production zone would be the default in its place. And so what that means is that if we were later to have those site-by-site rezoning discussions, it may be that something other than rural production might be the outcome for a particular property. But that's not today's argument, which is simply at its highest level, is not even is the horticulture zone the most appropriate zone, that's the section 32 question, but has the council met those mandatory tests for introducing its own special purpose zone as a concept? Yeah, at all.
Thank you for that. That's a good one. I guess that segues into the next question. that mandatory direction, you put our attention to section 58I of the Act. Can you just talk me through how that works? Because the standards are the standards over here, national planning standards, and then what this part of the Act is saying is, this is what you're saying, makes it mandatory. Can you just talk through that sort of structure of that one?
So the mandatory directions in section 58I(2). So if a national planning standard directs, the authority must amend each of its documents. So some of this is addressed at, for example, the definitions, and Ms. McGrath might be able to answer some of this, having been through part of this process herself with managing a district plan. Some parts of the national planning standards required immediate introduction without using Schedule 1. So some of section 58I is that, for example, you had to change your definitions over to comply. And that was not going to be a Schedule 1 process with debating because they were mandatory. And so you just had to introduce them. And then there were discretionary directions, so that if a national planning standards directs that a local authority choose from specific provisions, such as choosing from the list of zones, then you had to use Schedule 1 and go through the Section 32 process and submissions process. So Section 58I divides into those compulsory no correspondence will be entered into aspects such as the definitions, and then the council's choices about its plan, which is where it's making choices. Yes, that's right. And so there is this clear direction, I say, in the national planning standards, both in the purpose of having them in the first place, which was to introduce and require, as the statutory language, national consistency. And then within the standards itself, there is very clear split between what are mandatory directions and the zone framework is headed mandatory. So that statement that says the council must use the list of zones that we have provided, that is a mandatory direction. And then if there was going to be a special purpose zone, that's the exception. It has to go through a stringent test, but it is an exception to the mandatory standard, which is to use the zones that the standards selected.
Yes, thank you. On the last question, I try not to repeat some questions. So NPSHPL says highly productive land is fairly general zoning for production.
Yes, it says that highly productive land is only eligible for protection if it starts in one of those zones. Yeah.
Not arguing for it.
Yeah. Yeah. Yeah.
And you're saying general rural zone and production zone, like the general zone.
Because the NPSHPL expressly links it back to the planning standards and says, so in the legal submissions.
I just want to get that link.
Yeah. Now, where did I have that? What about the zone? Oh, okay. So paragraph 1.19 of the written, of the filed legal submissions. It's footnote 14 there. So NPSHPL clause 1.34 says that zone means the zones in the planning standards. And I have noted in that footnote that there is this sort of no man's land of nearest equivalent zone, but the NPSHPL says that nearest equivalent zone only applies if you haven't implemented the standards yet. But this proposed district plan is implementing the standards. And so that sort of waiver wouldn't apply. This zone's implementing the standards, and then the NPSHPL.
Does the Act say if you go and down the path of implementing the standards, you can't divert from the standards?
It doesn't use the language of you cannot depart from the standards. The standards themselves set out what that departure looks like. So for creation of a special purpose zone.
That's not my question.
Yeah.
Just asking whether you are down the path of implementing the national planning standards.
Yes.
Are you bound by the zones that they provide for.
Yes.
So you can only have two types of rural zone standards.
Um,
Excluding residential,
yes, exactly. Yes. So
you
for,
only have two types of zone, general,
yes.
but the standards say you can't have more than one rural. But here's where the question I'm asking.
Yeah, that's probably an evidence question for Ms. McGrath, but yes, yes.
Legal basis.
So my answer, yes, so my answer is the standards say that you can use a general rural zone and or a rural production zone. But if you were going to call them rural production zone 1, 2, and 3, for example, it doesn't provide for that. The mandatory direction is to choose one or both of those and then apply them. Yes.
One, other.
Or both. Yes,
None others.
that's right. And
Or no, I mean, for example, I was thinking possible to just say this we've got general production.
as a special purpose zone, if you meet rules. And so my answer to that is that the standards say, if you want to create one that was the horticulture production zone, you can only do that as a special purpose zone, and you have to go through that mandatory testing. So it has made it really tight.
I want to clarify.
Yeah.
And it's your legal submissions that those national planning standards with regards to use of zones are very directive and you can't be comfortable.
Yes.
What happens if you do? Then you want to abandon them?
You haven't met your statutory tests, which is why I started the legal submissions at the top. Well, what does the RMA say about this?
Go down the national planning standard.
Yes.
You've done.
And so if you don't comply with the standards, you have not met your statutory tests under 74 and 75, and on appeal to the Environment Court, then that I assume that would be the path you would take, is an appeal to the Environment Court to say, hey, these statutory provisions have not been complied with. These national level documents have not been given effect to, which is a breach of the Act and needs correcting. So that would be the remedy, would be, yeah, to go back to sections, I think it was 74. Yes, a government could decide that the standards could be amended, or could decide the standards are mandatory to implement. They have to be given effect to under section 74 and 75. Yes, correct. So a district plan must give effect to them, which means implement them.
I'm also trying to understand the framework.
Yes. What kind of apple have we been given here? Yes, and my reading of it all is that from the RMA provisions through the documents themselves, every tier is highly directive. The requirement to give effect to them, to implement them, and then the requirement of what they say implementing them means, all highly directive.
Just picking up on what the chair was saying, and your legal submissions are very helpful, so I think the panel would thank you for those. The room for improvement is Robert says, is really a 3 criteria to support the idea of effective zoning.
Yes.
So if for instance, a panel or people hearing it were not satisfied that the rural production zone adequately addresses what they wanted in terms of protecting horticultural soils and are you saying that that's something we'll hear from Melissa's evidence? That's going to be, we're going to hear that at a future hearing?
No, so that's in Ms. McGrath's planning evidence, but yes, but also I think there's some caution required with a council saying, well, the rural production zone doesn't protect these horticultural activities or infrastructure for 2 reasons. One, it has to. The rural production zone is required to give effect to the national policy statement on highly productive land, which includes the very stringent directives on fragmentation, on reverse sensitivity, and on protection of soils. If the rural production zone is not achieving those things, it is not giving effect to the national policy statement. It has to do those things. So that's the first thing. The second thing is that this council is writing its rural production zone. It has the opportunity to craft that zone, and it has to achieve those objectives. So the rural production zone is a zone that the council then gets to write the provisions in it. They can, and Ms. McGrath has provided some drafting that does, they can achieve everything they want to achieve with protecting these soils and this industry and this infrastructure by writing it into the zone. You don't need a different zone to achieve that. You just...
Submissions that we've got to the plan at the present time. Then are you able to point to submissions that provide the opportunity for us to write that?
Well, this submission gives a lot of scope, because this submission was to delete the horticulture zone and to use the RPROS to achieve those goals. I had given some thought to possible end goals. So if the panel, for example, had thought there should be a horticulture zone, but it should apply to all the irrigation or horticulture areas, that one's a bit fraught because it wasn't notified in that way. And I think the only way that outcome could occur is if the panel directed, or the council took upon itself to do a variation, because no one's had an opportunity to submit about a proposed horticulture zone in Opori or Waimate or Kaikoi. That wasn't notified, so no one's been able to. So that as a particular end goal, I think, has some procedural issues. But the end goal of saying that the rural production zone will protect soils, it will protect the industry, and it will protect the infrastructure, that was something that was clearly sought in this submission and in others. And so there's all the scope to do that, to make the rural production zone do its job.
So the special zone is to be considered. There's three criteria.
Yes.
Now, the significance one, that evidence,
Yes.
and then there's this question of practice.
Yes.
And it seems to me that the crux of it really comes down to theme.
Yes.
Barriers and practicality of it being managed through another zone.
Yes.
And I suppose really it's not a matter of what might be better. It's not that way. So the bar is quite high.
Yes.
And there's a practicality test. There has to be something about the special purpose zone that just can't be met by the two mandatory zones that we have to choose.
Yes, and that cannot, so the dictionary definitions were about effectiveness.
I don't think why.
Well, even if you could, spatial layer includes a zone, so it does really just take you back to B. I think you're right there. Yes.
It ends up becoming like an overlay, and
Yes.
they have
Yes.
possible. We've just been through the minerals,
Yes.
taking it out of the overlay. Recommended to take it into the overlay.
Yes.
So obviously everybody agree. So it really comes down, I think, to B.
Our argument is that it squarely sits in B, that the rural production zone is the zone that the government selected for this purpose, put it into the standards, and this council has the opportunity, and through the submissions process, has the opportunity to tailor that zone to do its job.
And we have determined the context of the act, we have to determine the context of the standards.
Yes.
And the HBL probably, that's companies inform us, what impractical means,
Yes.
what limits, that's, I thought that help us cut to the chase.
Yes. And I think
Yes.
I think I heard the 42A officer say that the rural production zone is wearing many hats, and it does apply to a very large area of the district. It always does for every district. That's just the nature of the beast. But the objectives, the policies, and then the provisions can drill down into that, either through defined terms, such as policies and provisions that apply to highly productive land, or through reference to things such as irrigation infrastructure. That can be a matter of policy and a matter of provisions. Yes,
That comes through in the evidence. I
Yes.
just wanted to clarify with him.
Yes.
Understand. You said,
yes.
Yeah, probably just, thank you. One of the things you said under the statutory requirement is council must prepare a PD.
Yes,
Also referred to national consistency
Yes.
and the issue of the national policy statement on highly productive land. It's a requirement. This PDP process started prior to the NPS-HPL.
it did, yes. But the decisions,
Back up.
well, I don't think you need to back up in the sense that when it was notified for submissions, I think it was the MPS notified for submission? Yes, it must have been, because our submissions were about implementing. Yes, so
All round.
so these processes are always iterative and submissions have sought alignment. The council's recommending alignment as well. The statutory provisions are that at the point you make your decisions, the finished product of the district plan has to give effect to the national policy statement. So it has come in at a fair point in the process. Everybody was aware that the national policy statement was coming in. In terms of the amendments that might be made to it, if those amendments are made before you make your decision, then it is the policy statement as exists as at the time of your decision that has to be given effect to.
So under that statutory requirement, we must prepare it. This is a really expensive process for the council.
Yes.
This is a very expensive process.
It's very
And I think
expensive.
Hearing one actually said, should we can it now and start again? So my next question is, you said NRC are not progressing mapping for a good reason. What's
Yes.
that good reason? They had no intention of, the NPS, HPA, the highly productive land had come out before they decided they had to map. Actually instructed them to map.
The NPS HPL instructed them to map and they started that process. And then this incoming government said that there would be amendments to the definition. And my understanding, my reading of the documents is that they have said, well, we will pause till we see what that amendment is. If that's
So
reasonable.
you can see my position with the council hat on, what do we do now? And I'm still at the point, why don't we just pause it, wait for the government to sort out whatever they're doing? But we've got that statutory requirement, we must those district plans. So
Yes.
you also referred to productive land.
Yeah.
A variety of iterations of what is productive, or the highly productive. And yeah, there's a whole lot of things there that's, you talk about mandatory versus exception, there's, so where we go from here, and you did say needs correctives, and I guess the evidence will come.
Yeah.
Tell us how to correct.
Yes, that's right. So in terms of the time frame and can you wait for the government to firm up what the amendments are going to be, the panel will be aware there are some time constraints on delivering decisions on a district plan. I gather that there has been an extension of time, perhaps to account for the length of time to get to where we are here rather than a projected length from there. I mean, I think I'd leave that to the council to advise you about those processes and timeframes. The statutory obligation is to implement the documents, and it seems from the hearing timetable next year that the amendments to the NPS HPL have been forecast by the middle of the year. Whether that's optimistic or not, we will see. But these hearings won't complete until at least the end of next year. So any amendments would be through before you are making your decisions. So I think that addresses part of it. Yes. And in terms of the cost, I mean, I think my client would want me to reiterate that the process is incredibly expensive for a council. Those submitters who choose to engage and choose to engage at an expert level and a council level, trying to ensure that the process sticks to the legal requirements and that the process delivers what's required. It's very expensive for the participants as well.
Yeah, I think, there's a few things that are coming out through the process, like the mapping scale is too large. It doesn't capture particular land masses. And it's also, there's some very evident mistakes.
Yes.
On what's in use, the other 1 and 3. Well,
And I think we will come to some of that in the hearings next year about, where lines are drawn in terms of zones, but at that higher principle level for
and if
the.
you're listening to the submissions yesterday from NRC, I actually challenged them on why aren't you doing mapping anyway? You could be doing 1 and 2 right now.
Yes.
Saying.
Yes, and I think we made some comments about, I sent a cabinet paper that says the NPS is going to be done and dusted by May next year. I'm not going to be placing any money on that outcome. Because I think that's very optimistic.
Yeah, the only intel I have is that by the.
There is a mandatory process.
Yes, that's right.
For change.
That's right.
And yeah, I think that would be all next year. Given that they haven't really even started.
The only messaging I have heard later than when I raised this earlier with the panel about the possible amendment is that mid-December has now been confirmed as a tabling date for some of this amending legislation. So we are now, what's the date today?
Tabling.
Well, for the legislation, that means in the House. So watch this space for the next 2 weeks to see whether the amending legislation makes it into the House. But we can only do what we have in front of us, and you will see I have not pleaded a case based on, well, LUC3 is out and you can ignore it. I'm not going to make that argument to you. That amendment hasn't been made yet. There's a commitment to make it. It hasn't happened yet. You have to implement the MPS as it is now. That's all we can do.
Same problem. Have to say, stop doing anything in that space until we change it at another specified time.
Yes.
Meanwhile, we keep carrying on and trying to meet our statutory obligations in a national policy environment that's highly uncertain.
Yes. I think the polite phrase was dynamic.
Notwithstanding the commitments to increase certainty.
Yes.
So, frustrating. Look, thank you. At least you set out a pathway of how you can achieve your submission.
Yes.
Voting framework. So at least we have a solution in front of us. That's
So we were going to start with Mr. Hanmore. Now his evidence is quite focused on this area. Evidence really is just that justification for agriculture zone, including LUC4.
Yes, I mean, I sort of saw some similarities between him and Mr. Cathcart.
Yes, that's right.
I don't want to any of this thunder.
Yeah.
There seem to be similar things. Would that be fair to say?
Well, I think so. Because of the nature of this submission, the brief for Mr. Hanmore was very specific, which is, look, the 42A has indicated, which came out of the Section 32 reporting, that LUC4 is a component of the zone because of its potential once irrigated. Can you please respond to that as a soil scientist? So we've given him quite a limited brief, and he was just going to take you to a couple of paragraphs of his evidence and then take any questions that you had. Mr. Hanmore, can you hear us?
Yes, I can.
If you could just start with your summary paragraphs and then answer the questions that the panel got.
Sure. I've been asked to provide evidence in response to statements in the Section 42A report that LUC4 land in the proposed horticulture zone has productive potential given the presence of the irrigation infrastructure.
Mr. Hanmore, if you could just take the panel to the paragraph numbers we're reading from, that'll help them to follow along.
So that was 3.1, then 3.15 of the Class 4 land included in the irrigation scheme area and included in the proposed horticulture zone, LUC Unit 4E2 accounts for by far the majority. There is only one 4S subclass unit and one 4W subclass unit, neither of which would receive a sustainable production benefit from irrigation. And then 3.18, LUC class 4 units within the proposed horticulture zone that are within the Keri Keri irrigation scheme are dominated by land that has moisture deficits over the summer, but that could not sustainably lift production through irrigation due to the risk of erosion and slope steepness. Thank you. So that was, yeah, that was my summary, was just those 3 paragraphs. Thank you.
Thank you. Thank you. I'll just see if the other commissioners have any questions for you. So just roll for a second.
Yeah, thanks, Mr. Hanmore. Did you by any chance see the evidence that Bob Cathcart presented to us as a panel yesterday?
I've seen his written evidence, yes.
Yeah. I mean, as I hear the evidence, as we hear the evidence that, of yourself and Mr. Cathcart, there's a consistency. Do you agree with that in terms of what you're putting to us?
Yes, yeah, that would be correct.
I mean, Mr. Cathcart certainly didn't reduce his evidence to 4 pages, more in the realms of planning evidence. But yeah, no, I just wanted to confirm that point. Thank you.
Sure.
Thank you, Mr. Hanmore. It's Commissioner Kensington here. Just wanted to confirm, would you describe your profession or your area of expertise as a soil scientist, or do you call yourself something different?
Probably, I'm a land management consultant, so I have, well, let's say I've mapped highly productive land, so I wouldn't call myself a podologist, but a soil specialist, yes.
Soil specialist, okay.
Yes.
Thank you. And I guess the other question I had was, in order to reach the conclusions that you've come up with in your written text, you've obviously done some mapping and some investigations.
Yes.
Would that would have followed the sort of methodology that Mr. Cathcart was talking about yesterday with the handbook that he brought along, the Bible, LUC mapping handbook?
Yes, yes. So I've mapped quite a lot of area around Keri Keri for various clients and various jobs, but some of my evidence is based on looking at, or some of that, and then looking at the LUC classifications and the soil maps for the area. So I obviously haven't mapped the whole irrigation area, but I definitely have experience, quite a significant amount of experience in the area.
Okay, well, that's helpful. Thank you. I didn't have anything else.
Yes. Yeah, thank you. I mean, we talked to Mr. Cathcart about this potential for LUC 4 to become LUC 3. I think his opinion was if the potential is there, you actually include it as LUC 3. And that's part of your assessment. Do you agree with that methodology?
Yeah, that will be accurate, because we have to, when you're mapping the land, you have to map it at its potential. So yeah, if it can be class 3, you map it as class 3 with the, like, for example, if it needed irrigation to be class 3, you map it as though it has had irrigation. So you wouldn't map it as class 4 and then say, oh, if we irrigation drainage. If we map it at class 4 and it needs drainage, if we drain it, it becomes class 3. You don't do that. You map it as class 3 as though the drainage was already done.
So in your assessment of the soils in this area, has the class 3 mapping been accurate reasonably? In other words, including class 4 that could be irrigated?
Sorry, I'm not sure. So you're saying, is the class 4 land, if it's irrigated, could it be class 3? Or are you saying is the class 3 areas that have been mapped, is that accurate? Sorry.
Yeah, that's right. I mean, in your view, and I know we're dealing with, mapping that was done in the late 70s and all of those inaccuracies, what have you. But do you think that in the class 3 soils that have been mapped, that it includes all of those soils that have the potential to be class 3?
Potential to be, none of them have the potential to be class 3. The ones that have been mapped, again, like you said, the mapping scale is fairly coarse, but if you're using the NZLRI, but the ones that are mapped as class 3, if we map it in finer detail, we're going to pick up class 4 land, and we're going to, which is quite common to find within those classes. So if we're looking at the maps and it shows class 3, if we did a field survey, we'd find that there's class 4, there may be class 6, there's going to be probably some class 2 in there as well. So but by and large, that I've found, especially the northern soil maps are quite accurate, but obviously not for use at a farm scale. Not sure if that answers your question. Sorry.
I'll put it in again to you in a slightly different way. I asked you questions about whether class 4 should include land that has the potential to become class 3. Mr. Cathcart answered to that question was, if it's got potential, it should already have been mapped as class 3. I think you agreed with me.
Yes. Yeah.
So therefore, what I'm asking you is, can you give us any opinion on whether the areas that are mapped class 3 now, whether that includes land that has the potential to be irrigated already mapped as class 3?
One of the, yes, the they've marked 3S2 as a common unit through that area, and that would need irrigation for the productivity to reach its potential. Like in the Kapira over the Landcorp station there, I've worked extensively on there. They plant avocados that will be irrigated, and that's the same kind of class 3 land we're talking about. So yes, it definitely, that class 3 land will need and benefit from irrigation.
Okay, no, thank you. I think, well, that's also for your information, that's consistent with what Mr. Cathcart's estimate. Okay, we're ready to use this.
You finished?
Yes, you're free to go or to carry on listening if you would like to, but if you could turn your camera off, please.
Thank you.
Thank you. Thank you. Oh, and your microphone, yes, thank you. Mr. Foy, can you hear us?
I can, yes.
Morning. If you could please provide any summary paragraphs that you wanted to as a refresher for the panel, just with some paragraph numbers. And then just to let you know, your supplementary, so your response to the council's evidence has been handed up in paper copy this morning. So the panel do have that in paper, but they have your original evidence in electronic.
Yeah, I just want to say, we've only just received, good morning, Mr. Floyd. We've only just received the supplementary evidence. We're happy for Mr. Floyd to read that to us.
Yes.
But we have read this promising.
So, Mr. Foy, if you could, the microphone's not great, but if you could just give any summary of your original statement, because the panel have read that, but they have not read your supplementary, so you will need to present that to them, please.
Very good, understood. Yes, I've prepared a summary of my primary evidence, and so I will run through that. Starts off that the horticulture zone is a special purpose zone, and as you've heard this morning, there are 3 mandatory requirements of creating a special purpose zone. And from my assessment, from an economics perspective, at least 2 of those requirements, the ones that I have assessed, do not apply. The horticulture zone is not significant to the Far North District, and the proposed zoning can be managed equally well or perhaps better by another zone or zones. So I've assessed the significance of the horticulture sector and run through a few points there from economic data. From my assessment, there are several factors that indicate that horticulture inside the proposed horticulture zone is not significant to the district economy. Overall, in the district, horticulture industry employs only 1.8% of the district's workforce, and of that, 1/3 is inside the proposed horticulture zone and 2/3 are outside. Horticulture also makes up only 1% of the total area of properties located on highly versatile soils, and horticulture accounts for only 1.7% of district GDP. More than half of the HPL that is used for horticulture in the district is outside the horticulture zone, the proposed horticulture zone, and horticulture is a small share of activities occurring within the Kerikeri irrigation region, which fairly well corresponds to the proposed horticulture zone. So horticulture is only 12% of employment in the irrigation region, and in the southern part of the irrigation region, 38% of the area by land parcels is occupied by residential activities, and a further 2% by commercial activities. So on a land area basis, horticulture is not the dominant activity in the horticulture zone. Horticulture employment in the district is not growing as the Section 32 report projected that it would. It's now 25% less than its 2018 peak, and in fact is its lowest point since 2016. Contrary to the Section 32 report's expectation of strong growth in the period 2016 to 2043. We're now over a quarter of the way through that period, and employment in horticulture in the district has declined rather than increasing as it was projected to do. In my opinion, the Section 32 and 42A reports do not explain why it's appropriate to have a special zone for an activity that occupies only such a small share, so 12% of an area, the area being the proposed horticulture zone. Based on the significant representation of non-horticulture activities in the horticulture zone, I question whether much of the area proposed to be subject to the horticulture zone is a working rural environment, quotes, as the 42A report describes, and zoning within the proposed horticulture zone should, in my opinion, better reflect the strong presence of non-horticultural activities. So as we've heard, that's a topic for another day, I suppose, with the other rezoning hearings. But horticulture is not enabled in the horticulture zone to a greater degree than other farming activities, as Ms. McGrath has stated in her evidence, which for me, from an economics perspective, calls into question why the horticulture zone is proposed to be applied at all. The horticulture zone is not proposed for any locations outside of Kerikeri, despite many places having a similar combination, I understand, of highly productive land, irrigation and horticulture activities, or the potential for that. These include around the Te Tai Tokorau Water Trust's proposed dams at Ngawha and near Waimati North, and the Opori Aquifer. So the question in my mind remains, if horticulture is such an important industry within the district as the council say it is, why is the horticulture zone not applied outside of Kerikeri in places which accommodate 2/3 of district horticulture employment? These data together indicate to me that from an economics perspective, there's no justification to apply a special zone for horticulture on the grounds of the significance of the activity in the location of the proposed horticulture zone. Ms. McGrath has outlined how similar the proposed horticulture zone is to the APROS in terms of activity status for most activities. I note that horticulture is only included as one component of farming activity and doesn't even have its own activity definition in the proposed plan. And that means the need to avoid use of the horticulture zone, the proposed zone, for non-horticulture activities is not reflected in the activity status of the horticulture zone. That means that, in my opinion, the horticulture zone is not materially different to the APROS from an economics perspective, and would be unlikely to achieve greater promotion or enhancement of horticulture activity in the proposed horticulture zone than would the notified APROS. Now, it's been covered in my primary statement some of the key attributes of horticulture land. Mr. McRae is generally in agreement with those, but I will run through some of those. I note first, though, that no evidence has been presented to show that horticultural activities in the horticulture zone are more economically productive than those in other locations, or that the proposed horticulture zone is more deserving from an economics perspective of having a bespoke horticulture zone applied to it, so that the nexus of parcel size, irrigation and presence of HPL is not, there's no evidence that that nexus is applies more in the proposed horticulture zone than it does elsewhere. So turning to irrigation, the Section 32 report notes that irrigation is available in the proposed horticulture zone, but it did not assess how irrigation is made available in practice, and didn't recognise that access to irrigation is not guaranteed, and in fact that there are some quite significant constraints with a Kirikiri irrigation scheme that had practical implications for horticulture in the proposed zone. Now, 2 hectares is the minimum site size for eligibility for supply from the Kirikiri irrigation company. And even for properties of more than 2 hectares, supply is limited to a maximum annual take. Now, Ms. Freya, from discussions with her, only the front part of her property, I understand about a half, is able to be irrigated due to those supply constraints. And from what she's told me, that her experience is fairly typical of other properties in the proposed zone. Ultimately, there's insufficient water to provide all horticulturalists in the proposed horticulture zone with all the water they want, which limits productivity in the horticulture zone. One of the criteria for the horticulture zone in the proposed plan is having access to a water source. And so if that access does not exist or is substantially constrained, one of the fundamental principles of the horticulture zone is absent, which calls into question, in my mind, the justification for applying the horticulture zone at all. The limited irrigation available in the proposed zone means that non-horticulture activities need to be undertaken to supplement incomes from horticulture that are, as Ms. Campbell-Freya advises, those incomes are often not positive. Parcel size, another key driver of horticultural productivity, is fairly good agreement between Mr. McElrath and myself that there has been significant fragmentation in the horticulture zone. From my assessment of current parcel sizes, 93% of parcels in the horticulture zone are smaller than 8 hectares, and 94% are smaller than 10 hectares. So there's that 8 to 10 hectares is about the range which is agreed in the Section 32 and Section 42A reports as the minimum size limit needed for productive horticultural activities. So a very large proportion of all parcels are smaller than that limit. That also applies when you look at it by land area. So 53% of land area of the horticulture zone is in parcels that are smaller than 8 hectares. And of the nearly 2,000 parcels in the horticulture zone, only 147 are larger than 8 hectares, and nearly 1,200, so that's 60%, are smaller than 2 hectares. So that's very well below any commonly accepted size that would support most forms of viable horticulture production, and also a size that would make it quite difficult to even aggregate parcels, as Mr. McElrath has suggested could be potential. But below 2 hectares, it takes quite a lot of effort to aggregate parcels from multiple owners to come up to any productive minimum size. So in my opinion, clearly the horticulture zone is proposed to be applied to a large geographic area in a relatively indiscriminate way that doesn't recognise the existing nature of activities within the area or the constraints presented by small parcel size. So while the objectives and policies in the horticulture zone chapter seek to protect against ongoing fragmentation, in my opinion, that horse is already bolted in much of the area. The 42A report doesn't appear to recognise the extent of non-horticultural activities and really understates the true extent of those activities. And the Section 32 report didn't present any lot size data at all in relation to the horticulture zone, only to the RPROs generally. So while I agree with Mr. McElrath that a piecemeal cookie cutter zone that covered only land currently in use for horticulture would struggle to manage the interface between adjacent residential and horticulture activities, in my opinion, the broad area of horticulture zone proposed doesn't adequately recognise existing activities, and some alternate approach is required. And that means that the horticulture zone as a special zone is not justified and is not appropriate in the context of the lot sizes that exist in many parts of the horticulture zone. Another key element of horticultural productivity is proximity and being on productive soils. There are large parts of highly productive land in many parts of the district. It's not specified in the 42A report why the horticulture zone is proposed to apply only to Kirikiri Waipapa. I interpret it as likely that the extent of the proposed horticulture zone has been driven almost solely by the spatial extent of the Kirikiri irrigation scheme, and I've formed that opinion in part based on the similarity of the spatial extent of the proposed zone and the scheme. In my opinion, access to the existing Kiri Kiri irrigation scheme should not be sufficient reason to distinguish Kiri Kiri Waipapa from other places of highly productive land, because there are other ways of accessing irrigation, and there are large areas that are irrigated elsewhere in the district outside the irrigation scheme area. Note that the Section 32 and 42A reports recommend including LUC4 land within the proposed horticulture zone, but not why the LUC4 land outside the proposed horticulture zone should not be included within a horticulture zone. So if the horticulture zone LUC4 land is good enough to be horticulture zone, why is other LUC4 land not also good enough to be so zoned? And considering the broad geographic spread of HPL throughout the district and the widespread location of horticulture activities outside of the horticulture zone in other places, there doesn't appear to me to be any justification for applying the horticulture zone only to Kiri Kiri Waipapa and not to other places. I understand that the Northern Regional Council submission supported applying horticulture zone to the Opori aquifer area and the area around the Matui Dam near Kaikohe. But in my opinion, the horticulture zone is justified in neither Kiri Kiri Waipapa nor other locations, and the RPROS would equally well protect horticulture activities occurring on HPL. So those irrigation attributes of irrigation, soil and parcel size combine to provide the opportunity to accommodate profitable horticultural enterprises. I accept that economic viability is not a valid consideration in assessing whether HPL should be able to convert to urban uses, and I note that impermanent constraints are also not a valid basis for such conversion. However, existing land use patterns, including highly fragmented land, means that applying the horticulture zone as proposed is unlikely to have the intended effect of enabling ongoing operation of horticultural activities in many parts of the proposed zone. Instead, the existing attributes of large parts of the area are likely to represent permanent constraints that will never allow productive horticultural activities to operate from large parts of the horticulture zone. And so the horticultural zone as proposed is unlikely to achieve the objectives stated in the proposed plan. So just in conclusion, then, I consider that the 42A reporting plan have failed to appropriately consider the relief sought by Ms. Campbell-Freer, and that the likely outcomes of the proposed horticulture zone are not significant to the Far North District and are very similar to those that would occur if the proposed zone were instead to be zoned RPROS. And secondly, the majority of land use activities in the proposed horticulture zone are not significant to the district. And while horticulture is an important industry in the district economy, it's not a majority activity in the large horticulture zone as proposed, nor is it likely to become so within the life of the proposed plan. I recommend that the horticulture zone is not applied as notified, and instead the RPROS is applied to parts of the proposed horticulture zone in which larger parcels are prevalent, and there obviously needs to be some flexibility to tie those together in a contiguous way, because we don't want that piecemeal cookie cutter sort of approach. But other zones need to be considered for parts of the proposed zone where significant fragmentation's already occurred. Now, so that's a conclusion of my summary of my primary statement. So if you would like, I will turn straight away to my supplementary statement and then take questions at the end if that's preferred. So my summary statement was prepared.
You proceed to your summary statement. We had the primary evidence.
Sorry, I missed that last bit.
We're happy for you to proceed to your supplementary statement. And I'll ask questions at the end.
Okay, thank you. So I prepared my my supplementary statement in response to the evidence of Mr. McElroth, which is dated 29th November. First heading I respond to is the consequence of not having the horticulture zone. Our focus of Mr. McElroth's evidence was that losing the activity associated with the proposed horticulture zone, and this is a quote, would undermine the local economy and reduce economic diversity and resilience. That was his paragraph 5. Now, as I stated in my primary statement, I don't consider that applying an alternative zoning to the proposed horticulture zone would have the effect of losing horticultural activity in the horticulture zone. From my assessment and in reliance on Ms McGrath's assessment of the planning environment, that would exist under the proposed horticulture zone as compared to the RPROS, there would be no material difference in the type of activities enabled in the area, the rules applying to those activities, and consequently to the type of activities that would be likely to exist in the area. Mr. McElroth does not consider the economic implication of applying a zone other than the horticulture zone to the proposed horticulture zone area, and therefore has not addressed whether there is any need to create a special horticulture zone, or whether the same or better outcomes could be achieved by applying a standard zone, such as the RPROS. Mr. McElroth states that it's not clear how I considered the growth outlook because it's not reported in my evidence. Now, the only reference I've made to projected horticulture activity relates to information taken directly from the Section 32 report. So I haven't independently tried to assess the growth outlook. I've purely relied on the Section 32A report as I just covered in my previous summary. Under my heading 4, I discuss the significance of the horticulture sector and activity in the horticulture zone. Now, Mr. McElroth correctly notes that employment is not the only economic metric that's important to understand when assessing the economic importance of the industry in the district, and that GDP is also important. I agree. However, I note that there is no spatially detailed GDP data available, which somewhat constrains us as to how we can consider that, and leaves employment data as the most accurate data that can provide an indication of sub-district industry trends. While it may be correct that horticulture GDP is increasing, that was not information that was presented in the Section 32 report, and therefore presumably was not information that informed the decision to create a special horticulture zone. Further, Mr. McElroth has not assessed where that GDP flows to. I have 3 responses to make on that point. First, increased GDP generated within the district may benefit the district if it flows into the district economy, but if the horticulture industry is growing as a result of large companies not located in the district and profits generated from their operation flow out to other locations, then the economic benefits of that additional activity will be limited in the far north. While those benefits will have positive flow-on effects to supporting industries, such as supplying materials for orchards and processing and packaging, those will be limited in scale. I haven't seen any assessment of where the economics of that growth may be flowing to, but I'm aware from a quick search that some of the region's larger horticulture operators are not owned locally. So Olivado, predominantly dealing in avocados, are offshore owned. Craigmore, who own large kiwi fruit orchards around Kirikiri, had to receive Overseas Investment Office approval to buy and develop their land. And Seeka, the kiwi fruit people, are owned by a mixture of overseas shareholders and shareholders around New Zealand, none of whom are local. So that really limits the positive effects that GDP can have on the economy when employment locally is not increasing. So employment of local workers becomes then, under my paragraph 4.5, an obvious way that increased GDP might flow back into the local economy because workers receive income and spend it in local businesses. If horticulture employment is not growing at a time when GDP is growing, this indicates that the economic benefits may not be sticking to the far north. If, for example, harvesting and processing methods are improving, including becoming more mechanised or automated, labour will not increase proportional to GDP, and that's potentially what we're seeing. Third, my understanding is that the main growth areas in Far North District's horticulture are outside the proposed horticulture zone, and mainly, particularly around the Opori Aquifer, where significant new avocado plantings have been and continue to be established. While that growth is important to the district economy, its success is not dependent on the potential creation of a horticulture zone in Kirikiri, and that growth should not be justification for a horticulture zone in Kirikiri. Mr. McElroth and no one else in the council either has not assessed where within the district the growth that he notes is occurring, and therefore his assessment does not, in my opinion, support a conclusion that the special horticulture zone in Kerikeri is required. So the question in my mind remains, if horticulture is such an important industry within the district, why is the proposed horticulture zone not applied outside of Kerikeri in places which accommodate 2/3 of district horticulture employment? Under my heading 5, fragmentation and irrigation, Mr. McElrath's assessment confirms my own in relation to fragmentation, namely that only about half of the horticulture zone land area is parcels that are more than the minimum lot size required for primary productive uses. I note that, consistent with the 42A position, that Ms. McGrath's assessment indicates that 10 hectares is an appropriate minimum lot size to enable high yield horticulture operations, and 94% of parcels, so it's a number of parcels, are smaller than 10 hectares. Ms. McGrath notes that 59% of parcels are smaller than 2 hectares, being the minimum for commercial connection to the Kerikeri irrigation scheme, and that's well below any commonly accepted size that would support most forms of viable horticulture production. So neither Mr. McElrath nor other council witnesses have stated how the proposed horticulture zone will help to stem the fragmentation that has occurred in recent decades, nor why the horticulture zone is required to stem this fragmentation in a way that the RPROS cannot. I agree with Mr. McElrath's statement that the Kerikeri irrigation scheme's water resource is available and is being used, and that there is existing irrigation used outside the proposed horticulture zone. There remains, however, no evidence from the council as to why irrigated horticulture land in Kerikeri requires a different zoning than irrigated horticulture land in the rest of the district, when the horticulture zone proposed does not contain any rules that protect against the loss of horticulture land in a way that the RPROS does not. So in short, I guess I'm saying that the RPROS would do this job equally as well as the proposed horticulture zone, and the horticulture zone is not required. So in conclusion, from my supplementary statement, I retained the conclusion stated in my primary statement, that the likely outcomes of the proposed zone are not significant to the district and very similar to those that would occur if the proposed zone were instead to be have a RPROS applied to them. And the majority of land use activities in the proposed horticulture zone are not significant to the district. And while horticulture is an important industry in the district, it's not a majority activity in the large zone as proposed. So I recommend that the horticulture zone is not applied. Instead, the RPROS is applied, which I've just covered in my previous summary, so I won't run through the rest of that. But so that concludes my reading through my supplementary statement. Happy to take questions.
Thank you for that extensive summary, Mr. Coyne. We'll see if we've got any questions for you.
You're certainly having witnesses comment on other witnesses. Expert evidence produces interesting evidence, I guess, and considerations. I just wasn't clear in paragraph 5.4, just towards the end, what you were saying. I wonder whether there's a word missing there. You're basically saying that provisions in the proposed horticultural zone provide no more than what the rural production zone provides. Is that what you're saying? Just seemed to be enough negatives in there that you lose the meaning. It just seemed to me what you're saying right at the end, again, at the end, is against the loss of horticultural land in a similar, in fact, the word similar way that the rural production zone does not.
Yes, it possibly could have been worded better, but yeah, that was the gist of it, that the RPROS does what the HZ seeks to do.
Right, thanks. Yeah, I guess the only thing I've got there in terms of having looked at the like and read what you said earlier is that, I mean, you're not short in getting involved into, the planning provisions of the scheme, so I don't see any problem in asking you questions in that respect. But is there any means by which the amalgamation of those smaller titles in the proposed horticultural zone, is there any manner that they can be, people can be encouraged to amalgamate those lots in any means?
I suppose the main encouragement would probably be financial. Is it worthwhile pursuing horticulture activities on their fragmented parcels? At the moment, I haven't undertaken sort of viability assessments of horticulture activities, but I've talked quite a bit to Ms. Campbell-Freer about her experience, and her experience indicates that it's actually quite difficult to achieve productive operations on these smaller sort of operations. Certainly below 8 to 10 hectares, it appears to be quite a tricky business. So for smaller operators that own a 2 hectare block, it's going to take quite a bit of cooperation with a number of neighbouring landowners to amalgamate parcels in such a way that there's any prospect of profitable operations resulting. That then also has to work around existing built form houses and driveways and all that sort of stuff that exists within the zone, and potentially the 8 to 10 hectares is even more when you've got to try to work around a number of houses on those 4 or 5 parcels that might need to be aggregated together. But yeah, Mr. McElroth's point that some amalgamation potential exists, yep, I take that point. I'd say the potential is probably fairly limited to the parcels at the larger end of the sub 8 to 10 hectare range. So maybe, 2 6 hectare parcels next to each other, potential there, but maybe not so much from the 4 to 10, just because it's never going to be financially worthwhile. Why would you sink a lot of capital into works that are going to be required to support horticulture when there's no return on that? So that motivation is going to be difficult, I think.
Thanks, yeah, that responds pretty well. Do you have any information relating to sort of the situation that might have occurred in the Bay of Plenty or the like, any similar situations around New Zealand where this particular problem's been faced, or the need to amalgamate titles to be able to exploit or to use that productive potential?
No, I haven't really looked into other locations, no.
Thanks. Thanks, Robert.
Yeah, thanks, Mr. Foy. My first question is in a similar vein to Commissioner Watson's about these smaller lot sizes. Are all in the same ownership? Or as Mr. McElroy points out, they might be leased. Is it, you have a handle on what that might be like? Actually,
No, I mean, that's quite a tricky sort of a thing to assess, I suppose. But yeah, no, I'm aware that there could be neighbouring parcels that are in the same ownership, and there could be leased. I don't have any information about whether properties are leased or not. And I do note that that fragmentation, there are potential ways around, and the NPS HPL sort of cautions against letting go of that fragmented land too easily. So that is something that should be understood. But I mean, there's been no evidence presented that there's any real prospect that most of those parcels, particularly those closer to Kerikeri, I suppose, have any real potential to form part of any productive parcel in the future. By the time that fragmentation is quite embedded with houses on each individual parcel, whether or not they're owned by the same owner, the houses are, I'd imagine, likely to remain, and getting some sort of cohesive activity going across multiple parcels would be quite tricky down at that, finer grained end of the range.
yeah, that's fine. I really was just wondering if there's any sort of certainty we can get, but it sounds like there's no data there to help us, so that's fine. So my second of 3 questions is your figure 5.4 in your primary evidence, which is taken, I think, from the Section 32 reporting based on old data, which we acknowledge, but you've concluded 12% of land use activity in the zone is horticultural related. Would Mr. McElroy agree with that? Are you guys on the same page with that sort of statistic?
I would imagine so. I'm not sure whether there's any more recent data than the 2016. I mean, it comes from LINZ, and they tend to be not that proactive at updating land uses. So I don't know whether there's been much in the way of updates to those land use codes since 2016. I don't imagine Mr. McElroth would have any better source of information. I mean, the LINS data is sort of the go-to, I suppose, because of its comprehensive nature. So we're sort of stuck with that, with its limitations. So I would imagine if there's been any changes since 2016, they might probably be along the lines of more land having been fragmented and lost to horticulture rather than any increase in horticulture. But I'd just, I suppose, stick with that. That 12% number would be about the sort of ballpark that we'd expect to still see on the ground today.
Pretty low number. How did you kind of get that? I mean, did you just take one of those colours from that map and divide it by the total area? Is that you got in?
That was from information provided in the Section 32 report. So there's a table in that report which says that horticulture activities account for only 16% of the land area in the South Kirikiri Irrigation Region South and 11% in the North. And so there were hectare land areas there. So that's a simple calculation of horticulture land divided by total land.
Is that one of the on the legend there? I can't quite make it out. Is that horticulture one of those colours?
Yes, horticulture is primary industry, market gardens and orchards. I think is the land use code from LINS that generally corresponds to industry. So it's sort of a grey brown kind of colour.
Grey brown that we can see there. Okay.
Yeah.
All right, thank you. And then my last question is also about spatial stuff. Your 5.7 in your primary statement.
Yep.
You said you've done some GIS assessment. That's mapping.
Yes.
Is that something that we need to see, your outputs from that mapping? Is there any kind of, you made a statement there about your assessment from mapping, but you haven't included that mapping. Is that evidence that we need to have in front of us, or?
I don't think so. I mean, I've just applied the HPL land use classifications and just done a GIS query on where in the district that lies. So it's just standard data. I don't think a map is required to show that. The text describes the quantities. I mean, I could produce a map of where land use classes 1 to 3 are within the region and 4. But that's publicly available information. That's I haven't sourced anything bespoke or special that I don't think requires any particular explanation.
Okay, no, that's fine. But I guess the important part of your evidence is the numbers, is the output that you've come to. So thank you. That's good.
Yeah, correct. Yeah, thank you.
Thank you.
Thank you, Mr. Toy. I know that some others submitted have said that they're hard to hear. Can you hear me all right?
I can hear you, yes.
Okay. The theme of this morning is that we don't need the whole zone because the rural production can do the same job. So I'm just going to focus on some of your economic statements, please. Under 4.1, you refer to employment, not the only economic metric, and GDP is also important. And then you also go and say we have no GDP data. How would you normally, in the economics world, measure GDP? Where is it?
Well, the ability to measure GDP is limited by the resolution that data is collected at, and so it's very difficult to measure it below a district level, which is sort of related to government statistics. It gets very difficult to measure at a sub-district level just because of privacy issues and the changing nature of activities, those sort of things that, below a sub-district level is quite difficult.
So then you say that there's a third of the income, or however you measured that economic activity, is in the Hort zone and 2/3 outside. Is that on a far north basis or Northland region?
Yeah, that's the district, the Far North District.
Okay. You referred to nil growth in the Hort zone or horticulture generally. Was it just this Hort zone or generally?
The what? Sorry, the lack of growth.
Yeah, you said growth was nil. I can't.
Yeah, growth is, so it's quite a bit off its 2018 peak and down from 2016. That's horticulture employment in the district.
So you measured that just on employment?
Yes, that was just employment. Yeah, I mean, and that's because employment is the only economic data really that's available at a sub-district level that allows you to compare the horticulture zone compared to non-horticulture zones.
Do you know if employment picks up our RSE workers?
Yeah, I believe so. Yeah, horticulture employment includes processing and packing and all the on-farm activities.
Have you had a look at investment in the new orchard developments that we've heard had, and also the supporting processing facility?
So the employment data that I've presented is 2023 data. So it's collected by Statistics New Zealand as a snapshot in February each year. So the Feb 24 data is not yet available. That'll be it really becomes available in December of the year once it's processed, etc., by Statistics New Zealand. So 23 data is the most recent available. So anything that was in place by February 2023 is captured in my data. Otherwise, it will be picked up next time there's a data update. So that depends on when those activities are established.
Okay. So the nil growth might actually be not quite a print, might relate to climate, biennial crop yield, could also be just market conditions.
Yeah, well, there's a bit of
avocado industry, for instance, the market for avocado is buggered.
Yeah, I mean, there is a bit of fluctuation in the data annually, but there's certainly, it's not like there's been 1 or 2 years which are much below a more healthy long-term trend. The general trend over the last few years has been a decline in employment. So I mean, that in my mind speaks to significance. But yeah, I mean, there's always the potential that will pick up again in the next year or two, and that growth will head back on a more positive sort of outlook. But there's also the possibility that it will continue to decline because horticulture is just not as significant as it used to be.
Yeah, the investment in the land would suggest that there is a significant investment. If you include land, the structures, the plant, time of production, and the licenses required for gold, for instance, we're looking at $1 million a hectare. It has declined slightly, but it's been that, isn't it, for a few years?
A lot of this is a long-term gain, I suppose, because they are such significant investments required. It's a long game played by some of these operators, and I think that's a large part of the reason why some of these new operations are large operations that have been run by non-local companies that have the capital to invest, and they have overseas backing or whatever, and that's why.
The economic dollar produced on an orchard in the general economy, locally.
Sorry, you cut out with the start of that question.
Do you know the economic turn? So a dollar produced on an orchard or farm versus how much that generates in the economy, the GDP?
I know generally that horticulture is more productive in terms of dollars per employee than other agriculture activities. So the capital intensive nature of it and the smaller parcels that can accommodate horticulture activities, the reason that exists is because of the higher dollars output. I actually haven't looked into how that money flows through the economy. Again, that depends on where the ownership is based, I suppose, in large part. But there is that sort of flow and effect to other industries and building materials for setting up orchards, and then the maintenance side of things, and the packing industry, and so that all comes into it as well. And that's why GDP is important, even though from the evidence presented, GDP is relatively modest, at less than 2% of GDP from horticulture.
Yeah, well, just on that rural productive or rural production land or our rural primary production up here, we've got forestry, fishing, coastal farming. The processing for the majority of those outputs is further south. Fish, everything's processed Auckland or south. Lamb is south of Auckland. 75% of our beef goes over the Auckland Harbour Bridge. We've only got 2 meat plants up here. Forestry is predominantly exported. There's very few that's actually milled in terms of timber here. And dairy, there's a large proportion that's exported. And the export of dairy goes out of Tauranga Port. I think that's where the GDP is measured, port export. So I continually say to our politicians and so forth that we've got to understand that north and the far north is the food basket of Auckland and drives our economy. And just pastoral farming has been proven for a number of years that $1 earned in that is about $8 churn in our economy. So it's quite significant. None of that shows up. So you also say that there's, where did you say that? There's only, that the land area in the hort zone is not dominant. So what is the dominant use?
So we talk about horticulture activity within the horticulture zone.
No, you said the hort, so just look at the hort zone that's proposed, and you said that the horticultural zone or the horticultural land use is not the dominant use. What is the dominant use in that hort zone?
I'd turn you, I suppose, to my figure 5.4, which was the subject of the previous question. And looking at that figure 5.4, and there's equivalent version for the Kerikeri irrigation region south, which shows fairly similar patterns. I mean, lifestyle activity is quite dominant within that area. The presence of, in this case, what's called primary industry market gardens and orchards, being the horticulture equivalent, and being that grey brown sort of colour, that shows up as being only about 12% of the total activities by land area within that zone. That pink colour, the lifestyle, is quite clearly fairly dominant. Some of the larger parcels are orange and used for stock fattening. Parts of the horticulture zone also in recreation land use, which I guess is not used for very much. But yeah, certainly lifestyle is quite dominant, and I think that shows through in the fragmentation. And it's that urban fringe of Kerikeri and Waipapa, which there's been strong demand for new houses there. People want to live there, and land prices have increased and made horticulture in parts of those areas less viable, and residential users will trump what horticulture can pay for the land.
The last question relates to the Kerikeri irrigation scheme. Are you aware why it was created? And who did that?
Yeah, I did do a little reading into the history of the zone. Yep, so I'm generally aware of why it was set up. And
so given the comment of limited availability that you mentioned and the restrictions on horticulture use, do you think we should be applying a first on or last on, first off process? And the last on is probably the Kerikeri Township will supply actually out of the Wainaro Dam, so that our horticultural users can actually use all the water that the scheme was created for.
It did occur to me in the course of preparing my evidence that there's possibly a better way than allowing lots of users a half share that can irrigate half of their property, and maybe some of the more marginal users or uses that are not productive in economic terms maybe they should be excluded from supply, and that there should be 100% supply available to some of the other users, so that production really is the key focus of where supply is. And I guess maybe that's part of the reason why there's that 2 hectare minimum. That's some attempt at sorting out which users should be eligible to take supply. I don't know that 2 hectares is going to achieve that, given the other evidence presented by the council that 8 to 10 is more like a minimum productive limit. So yeah, I mean, yeah, that's certainly a consideration. And there's, I mean, as I think Mr. McElroth also indicated, there is the potential for, and maybe it's being investigated now, for that take to be increased. But I guess there's environmental considerations there, and the extent to which it's possible, I'm not really sure. But certainly the irrigation constraint at the moment need not be a permanent constraint, and can be arranged in different ways to potentially achieve a better outcome. But I mean, upshot is that it doesn't really matter whether those, if that irrigation availability is rearranged, whether the zone that underlies the land is horticulture or ARPROS, the same result will be achieved, in my opinion.
Okay, thanks very much.
Morning, Mr. Boyd.
Morning, sir.
My very talented panel has asked most of the questions that I was thinking of asking, probably more articulately too. I think, but I only think there's one question it remains I want to put to you. In your responses, I think you talked when you were responding to Commissioner Kensington's questions about fragmented sites and potential for amalgamation. I think you talked about there's a threshold of economic viability. And I think you were sort of saying 8 to 10 hectares, was that right?
Yes, although that wasn't my assessment, that was council's assessment from the, I think the Section 32 report suggested 8 hectares and the 42A report suggested 10 or the other way around. But that sort of range was council's take on it. That was based on work they had done for them, I think. So I adopted that range.
Do you have any reason to dispute that range?
No, I don't. No.
Okay, right. So that happens to coincide with the rural production zones minimum subdivision standard, which has essentially doubled under the operative plan provisions. Where I'm going is we've had a lot of evidence put to us that the minimum subdivision standard should reduce down to 4 hectares and even lower. But in your opinion, that would then, if you were to do away with the horticulture zone and include its provisions in the general, or in the rural production zone, in order to maintain the economic viability that you've accepted in evidence, you'd need to maintain that minimum threshold of 8 to 10 hectares. Does that follow?
Yes, I think, yep, it does follow.
Yeah, okay. No, thank you. That's clarifying. Ms. McGrath, I can see you're rearing to go. However, we would actually just like a 5-minute break.
Absolutely.
It comes down to drinking too much coffee. So what we are scheduled to have morning tea at 11:30. We may have wrapped up by then and give you more welcome to join us. But I think we'll just take a little break now, and then we'll come back and maybe able to take more specific attention to you.
So, Mr. Foy, that was the end of your section. So you're welcome to stay or to go, but if you could please mute and turn your camera off. Thank you.
Good. Thank you.
Still hang around because we know it's at the end you might want to bring them back into.
Was there going to be a presentation from the council's economics today, or was that just for their presentation?
Like at the end of all of the evidence, and this being the last step, the council gets an opportunity to give us a verbal response prior to the written reply. Are we going to see Mr. Blackgrace around today?
He's online there. He's been online all morning.
Does he want to address us at the conclusion of this evidence?
We can chit chat with Mr. Ring, but it wasn't necessarily strictly an interview chat.
Yeah. Was he wanting to address us later on in the day? In the verbal.
Probably written by reply to the chair.
Okay, so for easy.
But if you have any questions, I'll be available to answer.
Well, let's consider that. And we'll get back to you.
Last correspondence I had with Mr. McGrath is that he had prepared a verbal if it was, if the panel would like to hear it.
Right. But of course, and if we don't hear it as part of your presentation, it'll be online and we'll come back here. It's going to happen today. So 5 minutes? Yes, 5 minutes now. Commissioner Watson. present your planning summary.
Thank you.
Okay.
Had prepared a presentation, but a lot of the matters we've already talked through. So I suspect if you prefer, I can just do a brief summary and then answer questions if that's going to be more useful.
Yes, I mean, you've got your usual presentation. Are you suggesting you dispense with that?
Dispense with that, yes, if you're happy
And
to.
just sort of run into.
It's recording, yes.
Okay. Yeah, look, I'm happy to be led by you in that regard. Yes, we have explored quite a lot of sort of planning-ish matters, but I think there's a few more to come, so we're in the
So at 1.2 of my evidence in chief, I have a summary of the evidence. Principally that the proposed horticulture zone and the proposed district plan is not the most appropriate mechanism to achieve appropriate objectives and does not fully align with Section 5 of the Act. And I've listed a number of reasons, which many have already been talked about today. The rural production zone objectives as proposed already adequately address the need to protect highly productive land, and I note that the 42A officer has recommended amendments to those provisions. The horticulture zone introduces unnecessary duplication and imposes restrictive and ineffective rules and fails to provide the flexibility required to allow landowners to fully utilise their land for a range of productive uses. The zoning criteria for the horticulture zone was to limit the zone to the Kirikiri Waipapa area that is overly narrow and fails to capture other areas within the district that are used for horticultural activities or where horticultural activities could thrive, especially in relation to existing and proposed irrigation infrastructure, and Mr. Foy explored that with you earlier today. The concern about reverse sensitivity within the Kirikiri Waipapa horticultural area does not warrant the establishment of a separate zone. And in my opinion, the rural production zone can or already manages reverse sensitivity through its provisions. And it can be improved to strengthen that if necessary. And the proposed horticulture zone does not provide any additional protection with this respect when I compare the two zones to each other. Much of the land that has been proposed to be horticulture zone is largely fragmented. And again, you've already explored that earlier today, making it unsuitable for large-scale horticultural operations. Whilst the Kirikiri Waipapa area has a certain level of investment, and I acknowledge that there is infrastructure in place, there is no evidence to suggest that this area is any more economically viable or productive for horticulture than other parts of the district. And finally, G, that the LUC4 soils are not defined as highly productive under the NPS HPL and should not be afforded any additional protection within the horticulture zone or the rural production zone. So that, in a quick summary, is the baseline for my evidence. When approaching this evidence, I approached it differently to how I would traditionally write a piece of evidence, as it is based on one outcome, that the whole zone be deleted. So I found it best to go back to first principles of Section 32 analysis and work my way through that, which has led to being quite a lengthy piece of evidence. I don't apologise for that. I thought it was important to work that through. And one key thing that I wanted to bring to your attention with respect to Section 32 is there's been a lot of discussion about the horticulture zone being appropriate. It's not the zone per se. The zone is a tool or a method, and I come back to it as the extent to which the objectives of the proposal are the most appropriate to achieve the purpose of the Act, and whether or not the provisions in the proposal are the most appropriate way to achieve those objectives. Now, I have worked through those in some detail through my evidence and highlighted areas where I think that the horticulture zone objectives, policies, provisions as proposed are not the most appropriate, particularly when compared to the rural production zone. So I have taken you through the appropriateness of objectives in paragraphs 4.4 through to 4.16. At 4.17 of my evidence, I've touched on the strategic direction. And I note again, as I've previously presented to this hearing panel, that the strategic direction objectives themselves have not gone through a Section 32 evaluation. And the reporting planner in this instance has determined that the strategic direction objectives RE01 and RE02 provide sufficient strategic direction to the rural environment as a whole, and does not consider it the role of the strategic direction objectives to provide direction on specific zones. And I disagree with that position, and I'm just reiterating again that I do not agree with that position, and I have turned my mind to how the production zone and the horticulture zone has implemented or given effect to those objectives, and that's at 4.18. I find that there is no support or direction that necessitates the creation of a specific zone limited to the Kirikiri Waikato area. There's absolutely nothing coming through in that proposed plan that leads to that conclusion. 4.19, again, I've touched on the duplication. And this is a theme that's come up repeatedly through the objectives, policies, provisions, that there is a large amount of duplication throughout the two zones. And again, I've expressed in my opinion that it's unnecessary to have this duplication. At 4.20, 21, I've talked through the national planning standards and the requirements for a special purpose zone, and Ms. Shaw took you through that very carefully. And I remain of the opinion that there's nothing about the horticulture zone reliant on the irrigation scheme and the constraints of the Kirikiri Waikato area that makes it different, significant for the district, sufficient enough to pass the test of A. And again, I've talked through at 25, 26, 27, or right through to 29 about the ability or the practicality of using the rural production zone. And I think there could be other spatial mechanisms that could be explored in ways that could be easily and simply applied. Moving further through the concept of Section 32 analysis and how one would approach zoning, I have then turned and assessed the efficiency and effectiveness of provisions in achieving objectives. And again, it's important to note that it's the most appropriate objectives that these provisions should be achieving. So again, I find that the rural production objectives are more appropriate than the horticulture zone. The provisions of the horticulture zone, again, it comes back to the duplication between the two. I don't see the need for different zones to be, I don't see the need for different rules to be needed. If different rules were needed, they can be incorporated in a single zone to achieve the objectives. Sorry, that's at 4.32. Again, Ms. Shaw identified this for you at 4.33. The horticulture zone relies on proposed policy 3, which seeks to enable horticulture activities and ancillary activities only, and that is an overly restrictive policy, which in my mind would then limit the non-horticultural rural production activities, farming, etc., which should be considered and enabled in when considering whether or not to give effect to the NPS HPR. Then have worked through whether or not the provisions themselves are efficient and effective in holding the line, which is what the reporting planner has considered as being required for the horticulture zone. And again, I've you've heard much of the conversation this morning about the extent to which the area is already fragmented. It's being used for a range of land use activities which are not horticulturally based. Some of them are rural production or productive uses, which may be appropriate in the rural production zones. But there is an existing fragmentation. There is an existing element of reverse sensitivity effects, which are limiting the ability for this land to be used for horticultural purposes. So therefore, having overly restrictive provisions is not necessarily going to reflect the most appropriate use, the most appropriate zoning for that location. So it takes you in somewhat of a circular argument. Turning to 4.35, I then have worked through from section 32 basis the efficiency and effectiveness of the horticulture zone criteria. Again, Ms. Shaw touched on this, but zoning criteria is really important when you are starting to look at what zones, locations, where, how, what the resource management issues are that should apply to a location and what is the most appropriate zoning for a location. No analysis has been done on the efficiency and effectiveness of the horticulture zone criteria. And so I've provided you with some commentary about that at table 1. As Ms. Shaw identified, it was automatically, this zone as proposed, automatically limited to the Kirikiri and Waipapa area. And I find that that's not the most efficient and effective way. And it was put to you earlier today that perhaps it might be more appropriate to consider it at a wide level. And certainly that's what some of the findings have been. But in my opinion, the rural production zone will do the job. Turning to section 5, I have worked through, so this zone and the need for this zone has been squarely focused on the Kirikiri Waipapa horticultural area and the importance of that area and what makes it special and unique, again, coming from the reporting planner. And so I've turned my mind to that. There was discussion throughout the 42A of the irrigation scheme as being regionally significant infrastructure or regionally significant. And I have looked at the definition of that in the regional policy statement and can find no supporting justification for why it would be identified as region significant, and it certainly isn't identified in the appendix of the regional policy statement. I acknowledge that the scheme is created and it is run as independently, so certainty in ability to access that water is controlled by a private entity. Access to that is limited. There's no certainty around that. So then I find that that is not an efficient or effective tool when considering zoning to identify an area spatially based on an uncertainty of access to infrastructure or access to water. And again, when one hears that there are other schemes and other water possibilities across the district, it just doesn't appear to make sense to limit the zone in such a way. So again, at 5.4, I have acknowledged that there are wider areas of water sources that certainly have been consented and are available. One of the points that was raised through the 42A is that the council has proposed a horticultural processing facilities zone, also another special purpose zone. I have not turned my mind to whether or not that zone is appropriate. But they have similar questions about whether or not it would meet the criteria under the planning standards. But I do note that that zone is not just limited to Kirikiri Waipapa. There are a number of locations outside of, and that whilst this zone enables the ongoing use of those processing facilities, such activities can occur in the rural production zone or could be enabled to occur in the rural production zone outside of highly productive land. So again, I find the the logic or the reasoning, the justification of having to have co-location and being close to horticultural processing facility zone is not an efficient argument in my opinion. The next justification was to prevent the increase in reverse sensitivity. Again, as I've already touched on and you've explored with other experts, that this area is already fragmented. It has, sorry, Siri's trying to talk to me. There is the ability to manage potential reverse sensitivity effects within the proposed production zone, particularly with the provisions. And again, this could be strengthened if this was a concern. I also note that the area is largely fragmented. The lots within it are rated as residential, rural lifestyle, and other land use activities, which would be considered to be sensitive to horticultural activities, and therefore constraining the future use or ability of that land. So the status quo is already gone. In terms of the importance of LUC4, I rely on Mr. Hanwell's assessment of the suitability of land use for soils in terms of it being productive. Again, I note that the NPS HPL certainly doesn't include consideration of it. The management of the fragmentation of that was put forward by the reporting planner as being important. It was seen to be the biggest threat to that soils, and in my opinion, the soils are not productive, therefore the threat to it is not there. Again, just flipping through to 5.10, I've worked through the investment level. So again, this concept of the Kirikiri Waikapa area is significant. The irrigation scheme provides, it is significant in the district. That was largely, the 32 has relied on the economic values of that, and Mr. Boy has addressed that, and he has concluded that it is not significant, and I rely on his expertise with that respect. Soils. And so just at section 6, I have touched upon the NPS and HPL, and I completely understand your frustrations of having to deal with it, and as a planner, that's our day job, is constantly having national policy change on you and having to react. So I can completely sympathise with you there. I do not believe that the horticulture zone is required, and I do not consider that it is necessary to implement the NPS HPL direction, and I have provided you with some suggested changes that could be made to the rural production zone, which just build on what the 42A officer has included to implement the NPS HPL should the horticulture zone not exist. As I interpret the NPS HPL, the onus squarely is applied to the regional council to undertake mapping, and therefore I do not support the concept of this holding pattern that the class 4 soils should be somewhat protected through a horticulture zone for their future potential mapping. And as Ms. Shaw has talked through, that's just, in my opinion, it does not reflect what the NPS HPL requires, nor does it give effect to it. With regard to the recommended provisions, I agree with a lot of what Ms. Pearson's recommended in terms of aligning the definitions and strengthening policy direction, and the changes that she's put forward to manage subdivision and activities in the rural production zone to give effect to the NPS HPL. I think it's stepping in the right direction. There are a few points where I disagree, and particularly with regard to specific referencing to LUC4 within the horticulture zone should it remain. And that, in a quick summary, is where I landed with the evidence. Happy to talk through any questions.
No, yeah, thank you. As I said, a lot of these issues have been clearly laid out for us, but also by other evidence previously. Yeah, regarding the LUC4 matter, you know, we really just have to wait and see where the government goes. It seems to me that regional councils aren't going to make any call. They make, we have to respond to both of them. So, but we do have over a year to go, so let's see how that pans out. I certainly rely on the legal submissions, Ms. Shaw, that about a special zone.
Yes.
Two zones to choose from, and then you have those three criteria. You want to implement a special zone.
Yes, that's right.
Yeah, that's the special also. Put that on the record. I think you said in your summary that there might be other methods that could be explored. Can you change your mind to other methods available in the national planning standards? That might, I mean, let's say without the play devil's advocate. If we were to find that we like the approach of providing specific provisions for horticulture in this location or potentially other locations, we accept the legal submission, legal situation, which is it doesn't reach the threshold to be a special purpose zone. What other methods do the national planning state does the national planning statement provide other methods that could be considered? Or is the only viable method to use one of those two buildings?
So where I think the planning standards do have a bit of wriggle room would be if you were to consider some form of subzone or a precinct.
That's where I was going to direct you. I'm going to cut the chase and say, could this be achieved by way of a precinct?
I think it could, and again, technically it would be part of the zone, and it would take some crafting of provisions. Effectively, that is what I've put to you are exemptions within the provisions, but that could be refined, and that could be a pathway forward.
So I sort of took the initiative to have a look at the national planning standard. I thought, oh, I didn't have a good definition. Do you have the definition of precinct? Yeah, I mean, I could read it to you. Use some evidence. No, it's not evidence, it's a statement of fact. It says a precinct spatially identifies and manages an area where additional place-based provisions apply to modify and refine aspects of the policy approach or outcomes anticipated in the underlying zone. So in this case, the underlying zone would be the outdoor zone.
Yep.
In combination, in combined plans with district plans and regional plans components, a precinct can be both single and applicable. That's good. So seems like it's a method.
Yep, it is.
We know that the plan doesn't have any precincts in it, but if, as I say, if we were to find that we'd like to enable horticulture with these methods, but in a more legal way and consistent with the planning standards, this could potentially be a lawful way to establish it.
And I understand the planning standards are pretty free and flexible with what a precinct looks like. I've myself have been through many plan changes.
If they establish any criteria, you cannot establish a precinct unless none of that.
As far as I know, that
It
doesn't.
just has to be related to the zone. And it would appear that the is fine. It needs to be said. That we don't need a response from you now. Exploring possibilities. Planning officers might come back with a very compelling argument as to why they still think that they are a special zone. Just wanted to, and I assume an overlay possibly isn't the right way to go.
I am relatively relaxed about overlays. I understand that you've had some previous.
It does have overlays.
It does have overlays, yes. because an overlay identifies distinctive values, risks, or other factors that require management. And I think you could possibly place an argument that the highly productive land would fit that criteria, and that could apply across the district. And that could, if you were to have two different zones, if you had a rural production zone and a general rural zone, then that could apply. I'm not sure where you will land with that based on other evidence that you have before you, but I do think an overlay could work in this situation.
Well, we have had evidence arguing the toss that there should be production zone. So that's not a ban, well, didn't pursue that belief any further yesterday. So I don't think we have any evidence. Okay, hey, well, that's been quite helpful. Thank you. I'll see if the other commissioners have any questions.
No, that'd be interesting to get a legal response to the last discussion, but I guess we're going to get that anyhow. Just while we're on point.
Just reading.
I just had a couple of things. I wondered if you wanted to take the time to walk us through your proposed changes to the RPROS provisions. If not, no worries, we can read them. If there's anything that you want to particularly highlight to us.
Oh, yeah, sorry. Sarah's just pointing out that I have provided a key of 2 different colours in the track changes just to highlight the points that I've brought through in response to the NPS HBR, and then the provisions that I've just transferred through from the horticulture zone. Again, I've not necessarily turned my mind to the particular nuances of this rural production zone, whether the provisions are appropriate. It was simply to show that it was not complicated to bring that horticulture zone through. And certainly the rest.
The series seems quite consistent.
Yeah, sorry. And again, I would be entirely open to working through this if there was direction to focus. I'm not necessarily fixated on this. It was more of a it can be done.
What experiment about how we could make us better.
My follow-ons, I'm particularly interested in proposed policy 6, agriculture zone, which talks about amalgamating boundaries, amalgamating land, boundary adjustments. I don't know how that could be achieved at a rural level, perhaps, but at a policy level, that's kind of responding to that fragmentation issue that you had at your, one of your kind of reasons, and the response to the fact that the horse is already folded. This is a way of turning the tide.
That's right. Yes.
Fragmenting aspect. Yeah. So have you brought that into your suggested changes?
Not necessarily. But again, I wouldn't be opposed to that. I do agree that that's something that could possibly be encouraged, particularly from a policy perspective.
Yeah.
Smart use of the boundary relocation, or I've also environmental benefit or transferable rights might be an option if you really wanted to get complicated with provisions. I've certainly worked through those. Yeah, it would be outside the plan, but I guess that's something that the council could consider. So to. Most of the experience that I've seen is that the rural production zone has a very strong policy outcome and strong basis for or against subdivision. So pathways through subdivision are often limited. Whangarei District Council, their operative plan, 20 hectare minimum lot size for subdivision in the rural production zone. Mangatapere's irrigation scheme, highly productive horticultural activities happening there. Rural production zone is protecting it at this point in time. So I think, again, if it was a key outcome. You could build in more policy direction around that into this zone. I just simply haven't had the time to turn my mind to what an ideal set of provisions would look like.
Thank you, that's understood. It's my last, I don't know if it's a question, but more of an observation. I found your evidence really clear and helpful, thank you. And in particular, I like the maps.
Yes, I can't do mapping.
And I and what they tell, the stories they tell. Is there anything you want to kind of highlight in those maps? I see you had them in your presentation. And you put it up on the screen if you need to, but are they similar to what Mr. Boy was?
Yes, and that's why I decided not to labour on them too much. It is what Mr. Boy has worked through.
They're probably a bit clearer than this ones. I mean, the ones with the yellow. I mean, I don't know which ones are the. They kind of are a bit clearer in telling that picture about what's irrigated. Well, are they different? Those heads, the legends, to what Mr. Boy.
They are different, yes.
So what
Yeah.
Because of time constraints, Mr. Foy produced his own mapping to produce his own evidence while Ms. McGrath was producing mapping to produce her evidence.
Okay.
And because of the short time frame, by the time this GIS mapping was done, he'd already written his evidence. So they are different. They're from the same data.
Yes, and so is there anything you wanted to draw our attention to on those maps? That you've got a range of different maps here.
So I can quickly run through the first set of maps that are included just highlight the number of lots that are less than 2 hectares within both the northern and southern areas of the identified irrigation scheme. So the irrigation scheme's there with a blue outline on all of the maps, and then the proposed horticultural zone is hatched, just to give you an understanding of where the differences are in mapping.
And then the green and the red, orange.
Green and orange is showing you what would be suitable or below the suitable size that has been put forward by council. So the less than 10 hectares is the green, and then the orange is just not eligible for connection to the irrigation scheme. So I take the point that the commissioner's made with respect to there could be amalgamation and leases that may enable uses, but they look fairly small and they do co-align with the residential or lifestyle land uses, which as Ms. Shaw's identified as slightly different colours. We've got a bit of a green scale happening in these plans, but also included in here is a map of the land use capability. So the soil classes relative to the proposed horticulture zone and the irrigation scheme catchment, which it shows an element of fragmentation, and certainly this concept of class 3, if it drops out, a fair chunk of that area it would no longer be highly productive land, which raises question again of suitability of having its own specific zone.
Which maps are those? Are they the ones?
No, sorry. So they're attached to my evidence again in the lovely green scale.
Oh, there you go. That's helpful. I think anyone's given us that sort of.
It's the first one we asked for. Overlay the irrigation scheme, the proposed zone and the land use classes.
So LUC3 is the darker green, LUC4 is the lighter
And class 2 is the bluey green.
green. Both the northern.
And the southern. So these are
So what's white? That's something else that's beyond 4, 5, 6, and 7.
must be no, we haven't identified them, so it will be lower.
There's no ones.
No ones. And again, these maps are based on the database. They're not ground truth. They're simply just what was the. Yeah. So there'll be elements, as you heard, there'll be discrepancies in it when you get closer down to.
That's really helpful. Thank you.
And then we've provided you with some lot density. So a bit of a heat map just to show what the different patterns and sizes. And sorry, pretty coloured.
Oh, that's it.
multicoloured map.
That's good.
Yeah, so again, that's just highlighting the range of lot sizes that you have in these areas, the extent of fragmentation.
That shows lots up down to 4 hectares too. It's interesting, sorry.
No, okay.
It's interesting to often the threshold lifestyle what sort of starts around hectares. They always have ambitions to possibly chop those in half. It seems to me, and I think it's generally it's the smaller lot size, the more attractive it starts coming as a continuum. But it seems to me that people can manage it from 4 hectares down. It seems to be the more or less the threshold where people think, oh, this is a lifestyle. You said that?
Yes, I would
So
agree
that's
with
that's
that.
enough information on which ones are in that range. And you can sort of argue the toss between 4 and 8 or 4 and 10 about whether it's, I mean, some people say 4 hectares and up is financially viable in circumstances, others say.
I certainly wouldn't proclaim to be an expert in that.
Yeah, no, that's what, no, but this gives us some information to
It's
see which sets in those sort of subsets of.
yes, and certainly it shows a nice picture of the larger lots are running around the outskirts of the irrigation scheme, so you can see where the pressure has come through the past subdivision development.
Then you got the rateable land use maps, which are very similar to what Mr. Ward.
Yes. And again, we were really just trying to see if there was a difference between the LINS data and the council rating data to see if there was any kind of useful information coming through in terms of what the council were perceiving this area as being used and rated for. So again, it tells a bit of a picture of the pale green area is the primary industry market garden orchards. So there are still some pockets of it through there, but largely lifestyle and residential.
So if someone was to come through and drive around with this map, it'd be reasonably accurate, or is this based on older data?
Good question. This is based on council's rating data.
Commissioner Local, probably better tell us that to drive around. No.
According to the GIS expert, the rateable land use data was sourced directly from Far North District Council and is assumed to be current as at November 2024.
Okay, so it's pretty up to date.
That's what it's rated as. It may not be used as that, but
That's very helpful. All that explanation, taking me through there.
You're not quite off the hook yet. This Nellie would like to ask some questions.
okay.
Brace yourself.
Already.
It relates probably more to Mr. Floyd's evidence that you relied on, really, but you dismissed the need for the horticulture zone related to economic viability in your statement just now. You said it's no better than other parts of the district. You also said proximity processing is not easy. I'll just challenge you on that if you want. So transport to processing and cold storage, highly important, and we have a number of processing and cold storage facilities in that.
Kitty area, yeah.
And Kapiro. And the impact on return. So I'm just going to specifically the orchard gate or the farm gate, orchard gate impact on returns. Just for example, transport, if they had to go through say there was nothing here and we had to go to Waianae, that cost is quite significant. I can give you an example relating to me transporting cattle south. When the green buildings were closed, they had to go through Dargaville, it extra $300 each way, just in fuel, road user and time for the races. But it's significant. If we come back and then export as well, export for. There was a trial done a couple of years ago. They might still be exporting out of Northport. Most of it goes out of Parliament. But the impact to returns to farm gate, I can't remember the exact numbers. She may know exactly, but just look at a 15,000 tray per hectare orchard, just per hectare, 10 cents a tray, just in transport advantage, it's $15 a hectare to the orchard.
Mhm.
So I just think, keep it careful.
So
out there, and like, well, that'll be maybe something.
Yeah, so I think to put that into a planning context, I'm not disputing I would know, you know far better than I would the economics of it. My point was that the rural production zone enables you to create those facilities and undertake those facilities should you wish to do so. So there's nothing in your plan that is stopping you from having those in proximity to each other. And yet, actually, if you had processing facilities up in Kaitaia, for example,
And
there's no horticulture zone in proximity to it, so you're not getting that benefit. So I think my argument, we're probably aligned in terms of the importance of it. I don't see the need to have a special purpose zone or the horticulture zone hanging on that processing zone being there.
so you mentioned also processing, you weren't sure if that was a requirement, but you hadn't looked at it, so I get that. Precinct again, as the chair has mentioned to me. And then you also mentioned rating as residential or rural lifestyle, so the reverse sensitivity problem is in existence. So I understood that from your messaging.
Yes.
That was all.
Yep. No, so the maps show it quite nicely that you've already got a mix of activities in this area, and provisions can only go so far to create the reverse sensitivity or manage those potential effects. And if the activities are already there, the horticultural process activities production is compromised. So how to find that balance is the challenge.
As a councillor, I can tell you, it texts, phone calls and emails about these issues every day. At least, so thank you very much.
Okay, well, I think that concludes all of our questions.
I have been squinting at the district spatial layers standard. So in terms of which is where overlays sit in the standard. So in contrast to that really directive language around zoning, the language in 12 district spatial layers, there is a mandatory direction, but it says where a district plan uses one, then you have to use the name that's given. So if you're going to use one of the spatial layers, you have to call it an overlay or call it a precinct consistently with the instructions. But that one's a very qualified. Where you use one, you have to use it consistent with the table below. Mandatory direction 2 says other than the spatial layers identified in the table, zones, overlays, precincts, you can't create other ones. So there's not even, for the zones, it says you can have a special purpose zone if it meets certain criteria. There's no special purpose overlay. You can only use, there's no special purpose spatial layer. You can only use the spatial layer. You can only use the spatial layers that are listed in table 18, which is zones, overlays, precincts, controls, so specific rule regimes, development areas, of course, is another one that's often, precincts and development areas are often considered as alternatives, designations, heritage orders. So it doesn't give you the possibility of creating a spatial layer other than effectively zone, overlay, precinct, or specific controls, which I would read as rules. But it's certainly where you use one, it's much more open than the zoning standard.
So I've only just got there today in response to your legacy, was trying to see a way through if we were to want to achieve the same objective, but lawfully.
Yes.
It seems that precinct, so if you were horticulture and spatial horticultural area, that we want specific provisions related to things that are going on in that area as part of a rural production zone would be a lawful approach.
It would be, and I think I'll direct the panel to your ongoing obligation under section 32AA to satisfy yourselves that a precinct or overlay, whichever spatial method you were wanting to using, was the most appropriate compared with using the rural production zone provisions. So I think the question the panel would need to be asking yourselves is there a spatial component that drives a spatial layer, or could the provisions, for example, referring out to highly productive land, which is a defined term, using policies and provisions, policies and rules that say on highly productive land, avoid fragmentation. So you would need to satisfy yourselves that there was something that was both spatial and more appropriately managed as an overlay than it was just managed within the zone provisions. That's the task you would have for you.
Yeah, thank you for that clarification. And we may go there. We may not, but I suppose what I wanted to explore was sort of presented to us was that the only option was to go back to the zone. And I just wanted to see whether there were other options. Seems to me that there possibly are. We're not signalling any preference either way. We're just sort of exploring the evidence before us and the options before us.
The only other
Certainly understand our obligations on that.
The only other thing I would flag is that perhaps, as I indicated at the outset, is that if you were considering a spatial layer for horticulture, another component is that, as I indicated earlier, I don't think anyone in submissions had asked for that to be applied to other specific spatial areas. So it's been raised as a general criticism of the horticulture zone, but no one has sought, that I understand, the council would be better to analyse this than me. And therefore, there's that jurisdictional scope concern that if the panel was minded to have a horticulture overlay or precinct, and that it apply in multiple locations, not just in Kirikiri Waikato.
Acknowledge that we don't have the scope.
That would be a scope issue, but it could be a variation.
Yeah, I was going to say,
It could be a variation.
there are signals that horticulture zone could be applied elsewhere, but they need to have a variation plan to do it. And I think that's been generally recognised.
And if that fell to the panel's consideration, that an equal treatment of all of the horticultural infrastructure areas or activity areas was an important outcome, that would tend towards either variation to pursue a spatial solution, or managing it within the RPRO's provisions, because those provisions can direct it to all of the horticultural areas, not just prioritising Kirikiri Waikato, because it can do it through policy and through provisions and reference to definitions. And so those are probably the key issues and considerations with considering a different spatial method, as opposed to using the zone and using the words in the zone. And the only other point I just wanted to make in terms of these maps, because we have Diane